It's a pleasure to be here and to see so many of you. We were discussing just before that this time last year we were all reading the tea leaves, and a year down the track, as Mr. Merrick said, we can sort of see the landscape evolving a bit, and it's a pleasure to be here to discuss these developing issues in what is really a very hot market. Now, before I go on, I'll introduce my panel. To my immediate right is Christian Schmidt. Christian Schmidt and I've now become friends, having hosted this panel last year. He is a disputes partner in Pinsent Masons' Munich office. He has more than 11 years of experience in the field of large-scale mass actions in Germany, both in the financial services and automotive sectors, and he's acted for claimants and defendants. Next to his work on collective redress projects, Christian is particularly focused on complex technical and financial disputes and the integration of legal tech into the field of dispute resolution. On his right is Leonard Bomer, who battled with Amsterdam traffic this morning, and we're very relieved he's here, otherwise it would have been just the two of us. He's a partner in CMS Netherlands. He specializes in insurance law, transport law, and risk management. He is the head of the Litigation and Insurance Practice Group and a member of the Advisory Committee on Civil Procedures of the Netherlands Bar Association. Importantly, he contributed to the Dutch chapter of Lord Justice Jackson's preliminary report on costs. So my panelists have a great deal of experience in Netherlands and Germany between them, and they can bring that experience to bear this morning. As Andrew mentioned, I'm an economist at the Brattle Group. I've been a practicing economist for 25 years. I've focused a great deal on cartels, abuse of dominance. I've done myriad regulatory investigations. I'm involved in several collective proceedings in the UK and in the Netherlands, including some related to interchange fees that Mr. Merrick was talking about, marine car carriers, which he was also talking about this morning, the McLaren claim and the FX collective claim, amongst others. Now, we're very pleased to be setting the scene here to talk about these really exciting issues in collective redress. We noticed that actually the jurisdictions are developing in very different ways and each have their own idiosyncrasies, and we'll try and bring some insights to bear on those. And also, of course, you'll all be familiar with the Representative Actions Directive, which a year down the track has been more or less transposed in many EU jurisdictions. Because there are so many things to discuss in this evolving arena, we thought that the best way to do this session would be to divide it into sort of three, to track the evolution of collective claims. So we'll start with the process of bringing the claim in different jurisdictions. We'll then talk about the certification of claims, or certification is a particular UK term, but you know what I mean, how it applies in other jurisdictions. And then we'll talk about settlements and disbursements, and then finally we'll give some concluding remarks about what we think are the really exciting issues in this area. Okay, so the process of bringing a claim in different jurisdictions, as Mr. Merrick pointed out this morning, it can be fraught with uncertainty, obstacles along the way, a bit of a roller coaster ride. I'll start with Christian on my right. Christian, can you shed light to how this is in Germany from your experience?
Yeah, thanks, Pinar, first of all, for the friendly introduction. Indeed, I'm very excited to be here with you today again, because I remember last year we were talking about how the Representative Actions Directive of the European Union will be transposed in the various jurisdictions. And at least this year, I can stop reading only tea leaves, but I can bring some more flesh to the bone, because now we have first draft bills in various jurisdictions. And I remember last year I said the aim of the Representative Actions Directive is to provide for a more or less cohesive, or at least minimum standard to bring collective actions in the European Union member states. But what we see now is that as far as we have got hold of the draft bills for the transposition, the landscape will be and will continue to be quite diverse. And as our panel is called Cross-Border Challenges and Opportunities, I see quite some challenges in that diversity. But maybe taking a look at Germany, because this is what my home jurisdiction is, where we have just seen a draft bill, and this is still highly disputed. So whatever I will tell you today about that needs to be seen with some distance, because it might still considerably change. But what we have seen in Germany is that we will now get a so-called redress action, which is basically the first serious collective action tool in the German landscape that will provide for actual redress, so for example, damages, and not only declaratory relief as it was until now. That's a big change, and I think this will change the procedural landscape in Germany. But at the same time, it comes with quite some serious limitations. And one of the big limitations is the limitation in scope. So it will, as far as we have seen in the draft bill, only be available to consumers or to small businesses. Small businesses are defined, I think, as of now, as companies with less than 50 employees. So quite some also potentially B2B collective actions. Just think about the cartel damages sector, where we have quite some B2B actions as well. They will not fall within the scope of that collective action. And so there will need to be quite some creativity going forward as to how one can bring those claims that don't fall into that scope in a collective way. There are assignment models, there are different creative ideas that have been in the market already, but they have been highly contested, and that brings insecurity, that brings uncertainty, and that is something, and our colleagues from the litigation funders, who I'm happy to discuss that with later, they might shed some light as to how that also influences their decision making, but that remains quite a challenge. But now we have that instrument, and we will see how that works. It will be a qualified entity that brings the claim, and not a claimant representative. As I said, it will be limited to consumers and small businesses, but at least that will be a first real collective action tool in the German market.
Okay, and you were telling me earlier that there's no possibility for collective claims in competition, or that one has to go through an extra hurdle to achieve that. Can you just shed a little bit more light on that? Yeah, so first of all, it remains to be seen how the draft bill will look like in the end when it comes to what areas of claims will be covered. Might well be that competition claims can be subject to the collective action, the redress action tool in Germany. Still, the limitation remains that it will be available to consumers and small businesses. So if you look at larger businesses who are bringing cartel damage claims together, and we have seen that in Germany as quite an issue in various cases, like the trucks cases, there has been a rail cartel, these kinds of things, then you might not be able to use a procedural tool, but you need to be creative in another way. And what can happen is that you create a special purpose vehicle and you assign all the claims of the various claimants to that special purpose vehicle, and that vehicle brings one claim to the court. And this has worked in the past, but the courts are really applying a lot of scrutiny as to the requirements for that to fly, because there have been quite some decisions that actually held this model as inadmissible for the reasons that there is potentially a conflict of interest between those who run the special purpose vehicle, the litigation funders that have, of course, a particular influence on how the proceedings are run. So it remains to be seen how that works. And this insecurity, of course, is something that is quite a deterrent if you're looking at bringing such a claim. Well, it's really interesting and quite different, I think, to the regime in the Netherlands. So, Leonard, could you shed a bit more light on that?
Yes, I was about to say that by contrast, the Dutch approach to the directive is like the French taunter in Monty Python's Search for the Holy Grail, whereby the response is, we already got one. And in Holland, we are proud that we already had a system in place that allowed for collective redress, mass actions, but with one very heavy restriction. You could not ask for compensation for losses. Anything else would do, but that's the one that you can't do. That restriction is now gone. And now we have got this other opt-out system as well, the new system that we're also very proud of. So we've got basically now two regimes. And in terms of these regimes, my feeling is that in 5 or 10 years' time, these two regimes will sort of merge or converge into one sort of regime whereby it is quite easy to start litigation. You have to have basically what the practice is that you found a foundation or an association. That can be done in a day with a civil law notary. That association and foundation has to have a certain format whereby the corporate governance of that association and foundation is basically secured. And one of the main issues is that the board should be independent from the lawyers or other. The board shouldn't be stakeholders, personal stakeholders. There shouldn't be a conflict of interest. And the other main criterion is that you need budget. Both budget to start a litigation and budget to pay the costs if you lose. And one of the issues that the Dutch government has sort of obscured is that we've said that we already have the system in place as described in the directive, except for one rule, and that's the loser pays rule. The Dutch government proudly announces that we have a loser pays rule, but that's, I would say, not entirely true, because we have an old system whereby the court will award a compensation of costs, but only to a slight amount of the actual costs. So that's not entirely in line with the loser pays rule. But it's quite easy to start, as long as you comply with the governance and the financial issues, and they're not that large, then you're ready to go.
Can I just pick up on that point about suitability? Because you mentioned two issues that I think are really interesting in the Netherlands context. And one is the suitability of a class representative. And the other one is about financeability. Could you expand a little bit more about the process for demonstrating both of those things?
Yes, again, there are two. In the old system, there was a bit of pressure, but there wasn't a huge requirement. In the new system, there's a very strict, significant requirement whereby you basically need to present a budget and financial, well, not a profit and loss account, but sufficient financial information to have the court determine that you're viable, financially viable. In terms of suitability, what happens is that part of the court documents is a description of the CVs of the board members and their lack of immediate interest in the outcome of the case. So that's that. When it comes to in the new system, and that's the new system has about 40 cases right now pending before the various courts, most of them here in Amsterdam, several of them in The Hague, and that's because the Dutch government resides in The Hague, so these are all claims against the government. I would say, just to wrap it up, that out of the 40 cases, a bit over 30%, 50% relate to human rights infractions, so focus at the state, and the other ones are what I would call the commercial cases, so the trucks cases and the Apple cases, the TikTok cases, what have you.
Right, that's very interesting. And I'm aware that there are some claims in the Netherlands that are not only seeking redress for consumers in the Netherlands, but on an EU-wide basis. Is there an additional threshold that has to be met for bringing in a wider group of consumers across the EU?
Well, there is one specific threshold that's been included at the very last moment through a large lobby. There has to be a tie to the Dutch jurisdiction. And there's quite a lot of legal debate whether that tie is allowed for in Dutch cases, or whether it is actually against at least the meaning, if not the wording, of the EU regulations. So there is that tie, and that's being litigated in almost every case, whereby people try to bring in mass actions on behalf of non-Dutch residents, that the defendants will say, well, you can't have them here in our courts.
Right, that's very interesting.
Despite the fact that, you know, the Brussels regulations say differently.
That's very interesting. Well, assuming that you have the funding, you have a rep, you decided the jurisdiction, the next stage, which is of particular interest to me, is what we refer to in the UK as the certification phase of the claims. And this is really where the uncertainty can come in terms of whether the CAT is going to certify the claim, which, of course, as Mr. Merrick said, following the MasterCard decision, everyone now has this view that there's a very low threshold and anything can be certified. But the lived experience is that's not necessarily the case, as we've had some surprising judgments, in particular the FX claims that were denied certification. Now, on certification, you know, we have opt-in, opt-out issues. There have been some so-called carriage disputes. Again, going with films, when I hear the words carriage dispute, I think something out of Downton Abbey, where people are in carriages are having a fight. But in the UK context, it means a dispute over who carries the claim, and these have been occurring in the Netherlands and in the UK. Now, I'll go to you again, Christian. If you can talk a little bit about what the German equivalent is of certification and the sort of issues that arise.
Yes, thanks a lot. So first of all, maybe a bit of a consolation. There is no carriage disputes in Germany because we don't have an opt-out regime, and there is no plan to introduce that. So nothing of that in Germany. Also, we don't have what you would call the formal certification stage. That doesn't exist in the draft bill that we have seen for the redress action. Still, of course, there are some requirements that you need to fulfill in order to bring a redress action in a collective way. And one of the central requirements is that the claims have to be of the same kind. You know, like this is what the law says. It doesn't say a lot more about that. And the question will be how the courts will actually determine what qualifies as claims of the same kind. And if you look at typical claims that come in collective actions, this will turn out to be a quite highly disputed requirement. And I think this will be extremely highly defended by defendants in those cases. And the reasoning behind it is, of course, you need to make sure that you have some commonality within the group of claimants that bring their collective claim here. And an example that has been provided in the draft bill was, well, if you look at the statute of limitations defense, for example, if there are claimants where the statute of limitation defense might already apply to their claim, then these claims are not of the same kind. Or if you look at, for example, a product liability claim, and you have a series of products, and only part of that series is affected by a certain damage or a certain defect, then also those don't qualify. I mean, these are quite straightforward examples, but there are for sure some examples where you can have different opinions on what qualifies as claim of the same kind. So I think this will be quite a central requirement. But that's most of it, and this is also because we don't have the opt-out regime, which requires a higher threshold at certification stage. Germany does not have discovery proceedings, pre-trial discovery, these kinds of things. That would require also maybe a higher threshold to get into that stage. And as Germany has a loser pays rule, also on that front, apparently the lawmakers don't see the need for a strict certification requirement.
Leonard, what's the
well, in the old regime, communality does play a role, but it's usually dealt with by the way the plaintiff phrases the claim, and the plaintiff is usually an association that acts either on the basis of assignments or of claims and powers of attorney, or both. And so the communality issue is less of a problem. In the new regime, it is still an issue in a gray area, because the plaintiff has to, if challenged, has to convince the court that it actually is a representative of a group. And for instance, we've had the discussion whereby the plaintiff, and of course lots of defendants do challenge basically the fan base of the plaintiff. And in one of the cases, the plaintiff said, well, presented the advice of the amount of likes that it had on social media, but the court dismissed that particular type of evidence, stating that just liking it doesn't mean that you actually back the claim. So there's that. How that ends up, I haven't got a clue. We've got one case, because in the new system, if there are multiple claimants, then the court needs to appoint one exclusive representative that represents all claimants, even if they're different groups. Although, as a good Dutch compromise, a Dutch court can appoint 2 exclusive representatives, which makes it a bit less exclusive, but at least you can move onwards. And we've got now one case whereby 3 claimant group have more or less the same claim against TikTok, but they represent, there's an overlap between the groups, and there's differences between the groups and the way the claims are phrased. And now the court has to decide, and it's still pending, how the court will appoint these exclusive representatives.
Well, you raise so many issues there, with there's a commonality of the claimants, the diversity of claimants. The commonality issue is an interesting one, I think, which the UK regime is still grappling with. We have a certification regime which is not supposed to go into issues of merits, and also, while it requires some commonality, it's possible for uninjured claimants to be within an opt-out proceeding, and it's quite possible for there to be significant diversity. For example, in the FX claims, there were it's estimated to be about 35,000 in the class, not like merits, but a very wide disparity in the amounts that were potentially being claimed. So this can create some problems, and of course, it goes to the heart of the opt-in versus opt-out issue. I guess you can skip this since you don't have an opt-out regime in Germany, but in the FX hearings, the CAT basically suggested to the claimants that if they had brought in an opt-in claim, that they might have had more success, and they were offered the opportunity to come back as an opt-in claim rather than an opt-out claim. Have these sorts of issues arisen, particularly in the Netherlands context?
They're bound to arise because the new system is based on an opt-out regime, whereby the opt-out statement should be made possible after the decision of the court, so in the first phase, to appoint the exclusive representative. Then the court will also basically find what the actual claim is, which is very contrary to the Dutch traditional approach, whereby the claimant just formulates drafts the wording of the claim, and that's what the court needs to respond to. And here the court has discretion to sort of reformulate the claim, thereby, influencing the groups and the communality issues and what have you. And how that will turn out, I have no idea. What we've seen, my impression of it, and it's a small group of very eager and experienced judges here in the Amsterdam court who really wants to take this process forward and who are adamant in providing relief to and find a solution to the claims and the issues at hand. So I expect a rather pragmatic approach. But all these cases are subject to appeal. It's different in Holland. You have just the right to appeal regardless. So what the Court of Appeal in Amsterdam will think of this is still a very black box.
Can I move on now to the role of evidence, experts, etc., at the so-called certification stage, and how the court may hear such evidence? Starting with you, Christian.
Yeah, that's a good question indeed. I think the directive, the Representative Actions Directive, actually provided for the opportunity for the member states to implement a more aggressive, let's say, approach to disclosure of documents, discovery exercises. In Germany, the lawmakers did not pick up on that. So the approach remains the same as before, more or less, in Germany, which means the claimant has to bring the claim with all the facts. You can also bring your own expert to the table, but that will just maybe confirm your opinion, but the court will then appoint its own experts to actually rely on their opinion. There is no pre-trial discovery. Disclosure of documents is quite limited. The only change that we've seen in the draft bill for the redress action is that while before, when you did not comply with a disclosure order by the courts, which happens quite rarely, one has to say, in Germany, if you didn't comply with that, the court could regard that when it came to the burden of proof and considering the evidence. Now they can impose a fine. But whether this will be a big change, I don't know. Honestly, German courts are quite reluctant when it comes to ordering disclosure of documents, and I would expect that to remain the same. So I think, to wrap that up, I think no big change there in the German market. Claimants need to bring their own facts. They need to investigate thoroughly. They need to make sure that they have the right sources for the facts they need to bring the claim, and there will be no big change on that front.
So Leonard, how is it in the Netherlands?
It's shifting. Back in the old days, the Dutch would say we don't have any any actions before the court, whether it is disclosure of documents, examination of witnesses, expert opinions. But in fact, we do. We do have these systems, and you see in mass claims that they're used more frequently, and especially expert opinions are important when it comes to figures, any kind of figures, because Dutch lawyers took, back in high school or secondary school, they took a package with lots of languages, bit of economics, but they stayed away from maths and anything that dealt with economics, and that's very important because most Dutch lawyers are they're good in rounding off or just the general basic ideas, but not the real economic things. And especially when it comes to the assessment of loss, the Dutch system is quite favorable to the use of experts, because the court either establishes the actual loss, and if that's not possible, it can assess the loss. Doesn't say in which way, so that's where the experts come in. And what you usually see in Dutch litigation is that the first 80% of the litigation is about technicalities, legal issues, preliminary issues, what have you. And then finally we're starting to talk about numbers. And then the lawyers shut up and the experts come in. And then it becomes a battle of the experts, basically. And again, in the Netherlands, if the court feels that the experts are, really far away from each other, or their opinions do not match anywhere, the court will indeed appoint its own expert and will probably rely on that expert, which basically means for any party that someone else has taken the ball and has run away with it. And you never know where you end up with a court-appointed expert. Apart from the fact that in most cases, it's really hard to get an independent expert after 5 years of litigation with all people involved, and all the experts are taken. So who is this independent expert anyway? And what's his or her expertise? It's a game changer, and one of my favorite issues is, at the start of the litigation, think of the experts. Just leave aside all the legal issues. What are we talking about? And back in the old days, any claim would amount to €1 million, and nowadays any claim amounts to €1 billion. But is that really so? Most of the time, it isn't.
Well, that's a really interesting point, because in the UK context, where we have a regime that supposedly doesn't have any sort of merits assessment during the certification process, we now have a sort of a halfway system where there are often multiple rounds of expert reports, pre-certification, and then there are some hearings with a minimal amount of cross-examination, but certainly questions asked by the tribunal and some questions from the other side's legal counsel. And the expert reports have to meet the criteria that they have a method for estimating damages, and they have data that will enable them to do that, which is the so-called Canadian standard. Some of them are light on a number, but not all. And so it's often very uncertain, because there could be a very wide range, what the range of damages might be in that pre-certification stage. And certainly it evolves and changes considerably post-certification. So what you're telling me is that it's unsatisfactory to not have any sort of number at this preliminary stage.
It is to me, yes.
Yes, and I think it's a considerable source of uncertainty as well for funders. Christian, do you have any comments from a German perspective on that?
Well, I think, that is an important topic, and I think having the number in place as early as possible is a central requirement, also when it comes to funding, but also for the court to go into the right direction, I guess. I think in Germany, of course, you will have experts, especially if you have a claim that heavily relies on numbers and that requires a damage model. You will have experts on your own side, but then you end up with the problem that Leonard just described. The parties have appointed their own experts already, they are taken, and then whom do you end up with as the court-appointed expert? But that's just a problem that we regularly see in the German system, and that is also why many companies prefer arbitration when it comes to their commercial disputes, because the expert regime is a lot different in there, as you know, and that is something that remains to be seen how that plays out. I think in particular in cases like cartel damages, I think this will be an important thing to watch. And we will maybe see also a bit of a change on that front, depending on how it goes.
Well, it's interesting. I mean, from the expert's perspective, it's very difficult to come up with a number when there's limited disclosure. So, when you say the claimants have to bring their own facts, There should be one set of facts, really. Otherwise, you have very different sets of facts from both sides. And those facts often don't become clear until sometime after the certification process. The UK regime has a reasonable amount of disclosure, but my experience of the Dutch regime is that you can spend years not getting any information, unfortunately. But anyway, we should move on to the next section. Assume that we have a certified claim, assume that we've been successful, that the claimants have won some damages. There are still issues at the settlement and disbursement level. We've just touched briefly on those. Leonard, I go to you first.
At this stage, basically what happens is that what's happened in the last 10 years or so is that because we're also proud of that we have a certification. We have a certification of class action settlements proceedings, and the usual disbursement system is that we have another foundation that basically deals with the doling out and the disbursements of the compensation, usually through very refined, if not incomprehensible sets of documents that basically tell you which classes receive what and how do you actually meet the requirements of these classes. So it's basically a private issue through this foundation, again, with people with experience in the field. So they draw a lot of on the experience of American firms that have dealt with mass disbursements. That's the main thing. And within the legal system, within the litigation, there's no significant experience yet. So we don't know.
What's the experience in Germany?
Yeah, I think Leonard summed it up quite well. We don't know because we have not dealt with that before. And I think the settlement of a collective action that maybe governs thousands, tens of thousands of claimants, and we have seen some of those cases that have those numbers, that has quite some challenges to itself. So the way the new German regime tries to deal with it is you first have a judgment on the merits that says, okay, this claim is valid and there is a claim on the merits. But the question is then, how much actually is the damage suffered by the individuals that have been affected? And the court will make a first estimation based on most likely also expert opinions, depending on the case. And then it will grant a total amount, and then will go into some kind of fund. And then you are at the distribution stage, if no settlement is reached. And in the distribution stage, you will have an administrator, and I think that the process is a bit designed like an insolvency proceeding. So you have an administrator, and the administrator will assess the damage that every single affected individual has suffered, and then grant part of those funds that are in that pot. And that sounds very complicated, and if you look at how the German law on damages works, it is actually a quite precise exercise. So it will remain to be seen how the German system can evolve, because so far the German courts really scrutinize the amount of damage in a very precise way. And you can't do that if you have 100,000 individuals that are affected. You can't look at every single document. You can't do it with that amount of precision. But so far we haven't seen that the lawmakers have actually gone so far as to change the material damage law in Germany to somehow cope with this challenge. So it will be interesting to see how the balance will be struck between the German precision and at the same time, just using the broad brush to make the settlement something that you can actually handle and the administrator can deal with. Because at the same time, the system provides for an appeal procedure. So if the individual is not happy with what the administrator has done, they can go to court. And if you imagine how that can play out, it can be a total mess. But as Leonard said, we don't know yet. I think this complicated procedure will actually drive many defendants into a settlement. But it's a really interesting topic, and it remains to be seen how it works, because we don't have that experience in Germany so far.
Well, it's interesting because Leonard said this is a private issue, and I think the view in the UK is, well, it's up to the claimants to decide how the settlement's going to be dispersed. But when you have a very diverse group of claimants with very wide ranges in claim damages within that group, then this can be quite a problem to resolve. And in the US, these issues go to the heart of commonality. And at pre-certification stage, if there are uninjured claimants, or if there are even claimants which may have benefited from the conduct, which sounds perverse. I mean, this is in a competition setting, but this has been an issue that's been raised in the context of the FX claim. Then there is a big question over, whether the distribution of the claim within the class is something that actually the CAT should have a view on. And in fact, I think the CAT sort of expressed a view on this when it said we would prefer this to be brought in as an opt-in claim. And the claimant said, if you say that, that's just banning certification by the back door because it's impracticable for us to bring in these opt-out claims on an opt-in basis. But certainly I think the court was going in that direction of wondering about the makeup of the class of claimants. Now, I think we're nearly up to time, but I wanted just some concluding remarks from both of you about how the things are going and the transposition of the RAD in your jurisdiction, starting with Leonard.
Concluding remarks. One thing, do not forget that we're Dutch. We don't speak English. We pretend to speak English, and there's a double jeopardy there, because there's a language issue and we have a completely different legal system. So whenever you speak to the Dutch and you feel that there's something, that there's some friction, something's not right, it's probably one of those issues, because basically you drive on the wrong side of the road. That's one. The second one is, as I said, bring in the expert in an early stage. Forget about we don't know, there are no facts, but try to focus on what the exposure really is about. And the psychological effect of you claiming $1 billion or being exposed to $1 billion is paralyzing in my view, and it shouldn't be, because you can then just break through this fiction and try to see what's really on the table in order to set your strategy, whether you're on the claimant side or on the plaintiff side. And on the claimant side is, as far as I'm concerned, put more effort in trying to get evidence, whether you work on the basis of assignments or on the basis of the claims, try to get as much evidence as you can, even through these preliminary sessions. It's been tried in a number of cases in the Netherlands, and then the court dismisses it. It's a subtle art, because courts are against, the Dutch Supreme Court has said time and again, you have to allow people to start preliminary gathering of evidence, either through disclosure of documents or examination, but the courts are against it because it basically stops them from doing anything else. But if you do it prudently, you can manage results. These are two of the main issues.
Christian?
Yeah, thanks, Leonard. That was very interesting, I think. And from yesterday night, when we were having dinner with our Amsterdam colleagues, actually I have realized that maybe Germany and the Netherlands are a bit closer than the UK and the Netherlands. We drive on the same side of the road. We like fried food. But at the same time, if you look at the transposition of the RAD and the regimes we have in place, we could see today that it is very different, and we have quite a diverse landscape. Although the RAD try to harmonize, but we see it's very diverse. And there will be a lot of challenges, also if you look at cross-border actions, which is something that the RAD wanted to encourage. But if you look at how the situation looks in the Netherlands, and if you look at Germany, and then the specific requirements that the courts impose on the claims, and then there are some countries in the EU that do not allow for litigation funding at all, like I think Ireland, for example. And then you have Germany that has litigation funding, but very restrictive. And then in the Netherlands, it's different again. I think that will be quite challenging if you look at cross-border issues. And if you look at just the national topics in Germany, I think it comes down to the incentive. Because it's all about the money in the end. And this regime that we see now provides for limited litigation funding. It has serious restrictions, and at the same time, consumers in Germany are quite often equipped with a legal expense insurance, and they can just go to their lawyer and have their individual claim in court. Why would they want to join a Representative Actions Directive that takes maybe forever and they don't know what comes out of it? So it might be that we don't see this big change all at once when the new regime is transposed. It might be a long development, a gradual development, and I think it is more that than a big step change. But still, it's a black box, and maybe next year we can talk about it again and see how it goes.
Hopefully, we will be, more enlightened next year. Just to conclude from what you were both telling me, we have the same piece of legislation, the RAD, but it's been transposed in very different ways, which perhaps reflect the cultural characteristics of the countries in which it's been transposed and the way that their legal systems have evolved, which I guess is not surprising. Given that, I would like to ask for any questions or comments that people may have. I think it's obviously too early in the morning. Well, thank you for listening to us. It's been a great pleasure.
Thank you.
Thank you very much.
Thank you.